Welcome to Work This Way, a labor and employment podcast. I'm Tina Emerson. I am here today with two Maynard Nexsen labor and employment lawyers, Jennie Cluverius and Fay Edwards. Good to see you both today.
Good to see you, Tina.
Nice to see you.
Glad you're here. Well, thanks for being on our podcast. We're going to be diving into the Supreme Court's recently issued unanimous opinion regarding reverse discrimination claims and how this impacts the workplace. Jennie, can you start off by giving us an overview on Ames versus the Ohio Department of Youth Service and the Supreme Court's subsequent interpretation of Title VII?
Yes. So the Ames case has caused a lot of buzz lately. Very interesting decision. And in that case, the plaintiff was a heterosexual female. She was employed by the Ohio Department of Youth Services for approximately 15 years. In 2019, she applied for a promotion with her employer to a newly created management position, but a lesbian woman was selected over this individual. A few days after she interviewed for this new position, she was removed from her role, her longtime role that she'd had as a program administrator, and accepted a demotion to a secretarial role within the organization. After that occurred, the department hired a gay man to fill her prior role. And after that is when she decided to file a lawsuit alleging that she was discriminated against based on her sex in violation of Title VII, which is one of the major federal anti-discrimination laws that we're usually working around with our clients. The district court granted summary judgment to the department, so to the employer, finding that Title VII plaintiffs in a majority group, as heterosexual individuals are, were required to actually satisfy a heightened evidentiary standard. And the Sixth Circuit affirmed the district court's decision. So the plaintiff ultimately appealed to the United States Supreme Court, and I should back up just momentarily. In its affirmation, the Sixth Circuit reasoned that because this individual was a member of a majority group, it was not enough for her to satisfy the not onerous first step of what everyone in our field is very familiar with, the McDonnell Douglas burden shifting framework. Rather, she had to establish, again, a heightened standard. So what they said was she had to establish background circumstances to support the suspicion that the defendant, the employer, is that unusual employer who discriminates against the majority. So that was the summary of the case. And the United States Supreme Court issued a unanimous opinion, which is incredibly rare for us to see out of our Supreme Court, holding that Title VII does not impose a heightened or a different burden of proof for majority group plaintiffs. So reverse discrimination claims, as they've come to be known under Title VII, have to be interpreted using the same framework as any other Title VII claim. Fay, I know will talk to us more about that decision, but I did want to say one other thing kind of to level set at the outset of this. Frequently, we hear the term reverse discrimination used. We are going to use that term for purposes of today's podcast because that is the topic that we are discussing. But as we will get into shortly, discrimination is discrimination. There's really no such thing as reverse discrimination under the law. It's kind of a term that certain courts and plaintiffs have come to use over time.
Right. And this has set quite a precedent. So how does this ruling change the legal landscape for these reverse discrimination claims in the workplace and the employers that are trying hard to defend them?
So it doesn't really change much at all. Like Jennie was saying, discrimination is discrimination. What the court did was provide clarity as to the evidence standard for these types of claims under Title VII. And with the heightened scrutiny, that background circumstances rule, the court invalidated it, which in result means that the majority group, as we use in society, the majority group of employees are now subject to the same burden of proof as a minority group. And this finding that the court ruled on with the Title VII disparate treatment, that it now provides that there's no distinction between major groups versus minorities. So there's no need to have a different burden of proof to be established or a prima facie case that needs to be met. Majority groups do not need to show compared to minorities. They're level playing field, essentially, and that's what the court did here.
And what implications does that ruling have on the McDonnell Douglas framework that Jennie was talking about earlier?
So in the court's opinion, well, alongside it, Justice Thomas and joined by Justice Gorsuch wrote a concurring opinion where Justice Thomas questioned the McDonnell Douglas. So for those who don't know, McDonnell Douglas framework is literally our go-to rule that helps guide us to determine if there was any sort of disparate treatment during the workplace. And it's essentially just to show that there was some sort of discrimination without the smoking gun. There wasn't direct discrimination. So this was our framework that we would use. And Justice Thomas had some serious issues with it. Number one, this framework is judge-made law. However, he said that we as the Supreme Court did not force anyone to use it. It's just been a custom, but it's not necessary to be used for number two, his second point, which is we have the summary judgment. And most times during litigation, the McDonnell Douglas test is definitely used during summary judgment to dispute whether there is enough facts, evidence to show that there was some sort of discrimination. Justice Thomas is saying, well, our courts are capable of ruling out whether there was discrimination without this McDonnell Douglas test. And number three, that it's just inconsistent with our rules with summary judgment. And finally, he says that it just fails to capture as a plaintiff ways to prove Title VII. It just seems, from his understanding, limits their ability to argue that they have been discriminated. So McDonnell Douglas is not necessarily eliminated whatsoever. But what it does show for the future and for attorneys and employers to consider that there potentially may be some shift again, a shakeup coming down the pipe if another case like this comes up to the Supreme Court and considers McDonnell Douglas and its ruling and its impact from this point forward.
And speaking of those additional lawsuits that might come down the pike, do you expect to see more of those because of this decision?
Well, they've already been here. There are cases here currently that are arguing on the basis of reverse discrimination. But what you will see more is that these cases will now probably surpass summary judgment, and in front of a jury, they're going to be much more sympathetic. They already are sympathetic towards this argument. So if anything, yes, you'll see an uptick per se, even though they're already here, but you'll see, if anything, more success past motions for summary judgment. Jennie, do you have any thoughts? I wonder, from your experience, what do you predict will?
Sure, I agree with Fay. These claims were already surfacing. We've seen several large jury verdicts as a result of what we've been hearing referred to as reverse race discrimination claims. I believe that this decision, and just in the current kind of political climate, people are becoming more aware, who are potentially in majority groups, that they actually do fall into protected classes that they didn't realize they fall into or fell into. And there's really more of an educational component. So I do feel like we will see an increased number of these claims. I believe that the EEOC's focus has become a little more broad as a result of this decision, and they're actually looking into and against, the backdrop of illegal DE&I, that we've heard that term thrown around a lot. The EEOC is also taking these types of claims more seriously than perhaps it has in the past. So it will be interesting to see what happens, but definitely believe there will be an uptick in these types of claims being asserted in courtrooms.
Well, with that uptick almost being assured, then what should employers be doing to ensure that their hiring practices are compliant in light of this? A lot of them must be looking back at what they've been doing up until this point and seeing what they might need to change.
That's a wonderful question, Tina. So I do think that step one would probably be doing a privileged audit of your hiring practices, determining where you may have issues, things that maybe your hiring managers were doing that they shouldn't have been doing, questions they should have been asking, or that they shouldn't have been asking, that they were asking, those types of things, because a lot of the issue here really comes in with a lack of training. And that would be the second component that I would highly recommend our clients, really take a hard look at. Many times when we see, especially a reverse discrimination claim lodged, it really stems from a lack of understanding on the part of the hiring manager involved or the other decision makers involved of the law. So under Title VII, when the law prohibits discrimination on the basis of, say, sex, it's not just women who are protected. It's not just females. It's also males. When Title VII prohibits discrimination on the basis of race, that also includes Caucasians, discrimination against Caucasians. When Title VII prohibits discrimination on the basis of sexual orientation, as we saw in the Ames case, it means you cannot discriminate, including against those people who are heterosexual, more the majority falling into that category. And I think, again, kind of going back to my original comment, a lot of hiring managers do not understand that people who fall into those majority categories are in fact protected under the law. And simply instilling that fundamental understanding in people that what they are supposed to be doing is searching for the best qualified candidate, regardless of these protected traits, and that it is in fact illegal for them to use these protected traits in making hiring, promotion, termination decisions. I think that is what is key to employers mitigating their risk moving forward, is educating their hiring managers on the law and what they can and cannot consider.
So the interpretation is to even the playing field truly for all groups of people.
Yes, which is what was intended by Title VII to begin with. Of course, the focus early on was on certainly certain demographic groups. But today it's been made very clear by the Supreme Court in the Ames decision that that law is intended to protect everyone who falls into each of the categories under Title VII: race, color, religion, national origin, gender. All of those things are protected categories that should not factor into your employment-related decisions.
Right. Well, we've talked a little bit about the McDonnell Douglas framework today. Can you describe exactly what the elements are that are included in that framework so those watching can have a better understanding of it?
Of course. And this is something that, unfortunately, if you get into litigation and a Title VII claim is involved, you're going to become very familiar with it very quickly. So under the McDonnell Douglas framework, it's a burden shifting framework. And under that framework, the plaintiff, the employee who is alleging some type of discrimination under Title VII, has to present evidence that they're a member of a protected category. So we've talked about race, gender, religion, national origin. Second, they must demonstrate that they were qualified for the job or the position they held or were seeking. Third, they must show that they suffered some type of adverse employment action. Certainly a termination decision is an adverse employment action. Demotion could be an adverse employment action. Under Ames, which we've been discussing, if someone is not selected for a promotion, that could be an adverse employment action. And then the fourth element that the employee has to show under that burden shifting framework is that the employer treated other employees outside of their protected class more favorably than they were. And these are employees who are similarly situated to that individual. So once an individual establishes those four elements, then the employer gets the opportunity to provide a legitimate, non-discriminatory reason for the employment decision at issue. And then if the employer does so, the burden shifts back to the plaintiff or the employee or the former employee to demonstrate that the employer's reason for the adverse employment action was actually pretext for some type of discrimination. So the reason given wasn't the real reason why the employee was terminated or why the employee wasn't selected for promotion. It was really a discrimination. That was the real reason. And then in the Ames case, of course, what we've been discussing is that the Supreme Court was trying to impose a heightened standard in the first four kind of elements that we were discussing on individuals falling into majority categories under Title VII, essentially requiring them to prove that in addition to those four elements, again, the employer was the rare employer who discriminates against the majority. And the Supreme Court as we've heard said, no, that's not what's required under the law.
Right. Well, thank you both very much for shedding some light on reverse discrimination, or simply discrimination in some of these cases. It'll be interesting to see where it goes from here after these decisions.
It sure will.
Absolutely.
Thank you, Jennie and Fay, for being with us, and we will see you next time on Work This Way.